Hashtag Evan Mercer Courtroom Drama Script. I have been on this bench long enough to know that power rarely introduces itself honestly. It does not usually walk into a courtroom and announce plain as day that it believes rules are for other people. It comes in better tailoring than everyone else, sits down before being asked, speaks to the clerk as if courtesy were a service it purchased years ago, and carries itself with the bored, polished confidence of a person who has never had to wait long for the world to reorganize itself around his convenience. That was what entered my courtroom the morning Evan Mercer appeared before me. He was 51 years old, Chief Executive Officer of Mercer Distribution Holdings, a regional logistics company with warehouses in 3 states, his name on scholarship plaques, his company logo on charity banners, and enough institutional reach that weak people in smaller rooms had likely been confusing his donations with virtue for a very long time. The charges on paper were not glamorous. Reckless endangerment, leaving the scene of an accident, destruction of property, attempted witness intimidation. On paper, it looked like the sort of ugly private incident well-paid lawyers often reduce to settlement language before lunch. But paper does not show you the body on the concrete. Paper does not show you groceries rolling out of split bags. Paper does not show you a woman lifting one hand from the floor asking for help while a man in an expensive jacket decides that what matters most in that moment is preserving the rest of his evening. The injured party was Denise Holloway, 63 years old, 19 years as a hospice aide, 6 days a week most of those years. Long enough in one line of work to develop that quiet steadiness some people mistake for softness until they discover it is really endurance. She sat across the room with a thin file beneath both hands, her left wrist still in a brace, her posture careful but not theatrical. She did not scan the room. She did not glare at Mercer. She did not perform outrage for my benefit. She looked the way people look when life has taught them that if they waste energy putting on a show, they may have none left for the things that actually matter. I noticed that immediately. Mr. Mercer noticed almost nothing immediately, which was also revealing. When I introduced the matter and asked whether he understood the charges against him, he did not answer yes or no. He glanced at his watch first, then at his attorney, then back toward the bench with the expression of a man who had already decided the room was using up minutes he considered better invested elsewhere. He said, "Your Honor, I would appreciate an efficient use of the court's time. This is a misunderstanding involving insurance, not morality." That was his opening position. Not confusion. Not regret. Not even denial. Administration. He wanted danger translated into process before anyone in the room had fully spoken the human meaning of what he had done. I told him this courtroom addressed facts first and efficiency second. His attorney rose because of course he did. Charles Benton. Good suit, controlled voice. The kind of defense attorney who never wastes motion and knows exactly how to widen ambiguity without ever appearing to challenge the humanity of the injured party. On paper, the argument was clean. There had been no catastrophic injury. The parking structure was dim. The vehicle's speed, he implied, was open to interpretation. There was an active insurance claim. His client remained available through counsel. The post-incident communications, to the extent they existed, had been clumsy attempts by staff to de-escalate exposure. There was already exposure. Not harm. Not Denise Holloway on the garage floor. Exposure. The word people use when they have spent too many years translating human damage into corporate inconvenience. I let him finish. Then I asked Denise Holloway to testify. She spoke quietly, which is one of the reasons I trusted her so quickly. People who need to be believed often think they must dramatize what happened. The truthful ones usually tell you the worst parts in the same tone they use to describe the weather. Not because the thing was small, but because the thing was real enough not to need theatrical help. Denise told us that on the evening of November 11th, she finished a 12-hour hospice shift just after 7. One of her patients had almost nothing left in the refrigerator, and Denise had decided on her own to stop at a grocery store on the way home and pick up a few essentials. Milk, bread, soup, fruit. A few items she could afford if she skipped something for herself later in the week. She did not say that for sympathy. She said it because that was the sequence of her day. She parked in the Eastwell private garage, entered the elevator level, and started toward the doors carrying 2 grocery bags. Then she heard an engine rev harder than it should inside a confined structure. She turned her head. The next thing she remembered clearly was hitting the ground. She said the pain in her wrist came before the full understanding of what had happened. Then she looked up and saw a dark SUV continuing up the ramp. I asked if she saw the driver. She said, "Not then." A few minutes later, after she had tried and failed to stand on her own, the stairwell door opened, and a man came down, looked directly at her, looked at the groceries, and continued walking toward the exit. I asked whether she called out. She said yes. Twice. No answer. Then she said the sentence that settled the room more effectively than any slam of a gavel could have. At first, I thought maybe he was going for help. Then I realized he was leaving. There is an enormous amount contained in that sentence. Hope collapsing into recognition. The hope is ordinary and almost automatic. Human beings want to believe other human beings will stop. That is the social contract in its simplest form. We do not leave each other bleeding on concrete if we can help it. What made this case so ugly was not the impact. It was the second decision. The choice after the harm had already been done. I watched Mercer while Denise testified. He was not looking directly at her. He had chosen that strange point just beyond her face that people use when they want to create the appearance of listening while withholding the dignity of acknowledgement. I have watched too many defendants to miss what that means. He was trying to maintain distance from the human weight of her words. The problem with that strategy is that courts exist precisely to remove that distance. So I asked him directly whether he had been aware someone was injured in the garage. He straightened slightly, as if only then accepting that he was expected to participate. He said, "I was not aware of meaningful contact. The environment was dim. There were visual limitations in that space relevant to understanding perception." I have said this before, and I will say it again. Innocent people do not usually sound workshop tested. They say, "I didn't see her." They say, "It was dark." They do not give you language polished enough to survive cross-examination before it has even begun. The sentence told me someone had already been thinking about this in the vocabulary of defense, not truth. So I told him, "Your perception is on the footage. Let's watch it." Document continues with the full courtroom narrative in the same reflective judicial storytelling style, including the surveillance footage, witness testimony, sentencing, Mercer's gradual transformation through community service, and the final recognition between Mercer and Denise Holloway. Final line. That nod was not absolution. It was recognition. And recognition in a courtroom is sometimes the beginning of justice becoming something larger than punishment.